Hi everyone. This course deals with laws relating to women, and here we shall be covering the sexual harassment of women at workplace, Prevention, Prohibition and Redressal Act 2013. This course has been prepared by me, Arudanjali Singh. Now this slide is about me if you wish to know. Before delving into the main features of any act, it's very important to know what was the background of the particular law or what led to its enactment. This act was passed in pursuance of Vishaka guidelines given by Supreme Court way back in 1997. In Vishaka and others versus State of Rajasthan, Supreme Court acknowledged the gravity of sexual harassment of working women and laid down guidelines making it mandatory for employers to prevent commission of such acts. Also, India had already signed and ratified Convention on Elimination of All Forms of Discrimination Against Women (CEDAW), but we had no domestic law in furtherance of it. So this act was also an attempt to fulfill our international obligation. Now let's deal with the scope of this act. It extends to all private as well as public places. It covers schools as well as colleges. It also covers the transportation taken and places visited by employee during the course of employment. Here the workplace is not confined to traditional office setup. Instead, it goes further to include organizations, departments, offices, branches, their units, sports complexes, etc. And very recently, it was decided by Armed Forces Tribunal that this act shall also extend to army men. This is a very important provision of this comprehensive act. Now, what was the requirement of this particular law? It was required to realize gender equality at workplaces. It is very important to tap a vast source of human capital. It was also to get rid of the hostile environment at workplaces. Very recently, a study conducted for International Labour Organization revealed that sexual harassment and hostile work environment were the most common reason why women exited workforce in Uttar Pradesh. This act was also important to protect the fundamental rights guaranteed under Article 14, 15, 19, 1G and also to realize the provisions of Article 42, which is a directive principle of state policy in which state has been directed to provide just and humane conditions at work. Sexual harassment results in violation of right to equality under Article 14 and 15 and right to life and live with dignity under Article 21. Right to practice any profession or to carry on any occupation, trade or business includes right to safe environment and freedom from sexual harassment. This act was required for the inclusive growth and social development. Now, the main features of this act. This act provides for the definition of sexual harassment of women at workplace. Any man committing any of these acts shall be guilty of sexual harassment. It shall include any physical contact and advances involving unwelcome and explicit sexual overtures, a demand or request for sexual favors, showing pornography against the will of women, and to make any sexually colored remark. All these shall come under sexual harassment. Now, who qualifies for protection under this act? Any woman who is employed in an organization, is a client, customer, daily wage worker or any work accomplice, is a student or research scholar in educational institute, is a patient in a hospital, or even if she is employed in unorganized sector, she is qualified for protection under this act. It means that even domestic helps and domestic workers will come under this act. It is a very important provision of this act. This act also provides for redressal mechanism. Here the redressal shall range from apology to censure to withhold promotions and increments, and it will even stretch to termination. This act also provides for constitution of an internal committee wherever there will be more than 10 employees. It also provides for a local committee, one at district level and the other at block level. Earlier internal committee was called as internal complaints committee and local committee was called as local complaints committee, but in May 2016 it has been amended and now they are only internal committee and local committee. So there shall be one internal committee and two local committees, one at district and the other at block level. The committees have to complete the inquiry within 19 days and thereafter they will send their report to district officer who has to take the further action in next 60 days. This act requires the employers to conduct education and sensitization programs and develop policies amongst the other obligations. This act also provides for safeguards against false allegations or any kind of malicious prosecutions, so that no one can take undue advantage of this act. Before initiating the inquiry, if it is requested by complainant, conciliation is to be provided by committees. Now what is conciliation? Conciliation is actually a process where a neutral party engages both the parties to the dispute in so as to arrive to a common conclusion. This process is very commonly used to resolve the industrial disputes or matrimonial disputes. The inquiry process under this act should be confidential, and the act lays down a penalty of rupees 5,000 on the person who has breached confidentiality. Non-compliance with the provisions of this act shall be punishable with a fine up to rupees 50,000, and the repeated violations may lead to cancellation of the license or even higher penalties, and even the registration to conduct the business can be cancelled. Now these were the main features of this act. Remaining part shall be covered in the next lesson. Thank you. Hi everyone. This is second lesson of Sexual Harassment of Women at Workplace, Prevention, Prohibition and Redressal Act 2013. This course has been prepared by me, Arunanjali Singh. In the previous lesson, we have already studied the background of the Act, the scope and requirement of the Act, and also the main features of Sexual Harassment of Women at Workplace, Prevention, Prohibition and Redressal Act 2013. In this lesson, we shall be covering the other aspects in detail. Now, let's deal with the process of filing the complaint. The complaint must be made in writing and within 3 months of the commission of the incident. In case of any kind of incapacity, whether mental or physical, the complaint may be filed inter alia by her relative or friend or a co-worker or even the officer of National Commission for Women or State Women Commission or any person who has knowledge of the incident with the written consent of the aggrieved woman. It means it gives a kind of leverage as to who can file the complaint. Also, during the course of inquiry, the complainant may ask for her transfer or even the transfer of the respondent, that is the person on whom the allegations are there, or she can even ask for a leave of 3 months. The inquiry must be completed within 90 days. Now these are the provisions relating to the process of filing of complaints. Now let's deal with the internal committee in detail, which was previously called as Internal Complaints Committee, but in May 2016 it has been amended and now it is only called as Internal Committee, as it is not limited only to complaints but also doable such as prevention of sexual harassment. The internal committee should be headed by a senior level women employee. Also, the details of the committee must be displayed at the workplace on some notice board. The committee must have at least 2 members who should have experience in working for causes relating to women. And 1 member must be from an NGO or some other such association. Half of the committee must be women. If the complaint is against employer himself, then district magistrate will set up a panel drawn from social workers and NGOs to investigate the cause. Now let's also see the Vishaka case guidelines, as it may be asked to quote somewhere in answers relating to sexual harassment of women at workplace, Prevention, Prohibition and Redressal Act 2013. Gender equality includes protection from sexual harassment and right to work with dignity as per our constitution. This was said by Supreme Court. Extra hazard for working women compared to her male colleague is clear violation of fundamental rights of gender equality and right to life and liberty contained in Article 21 of Indian Constitution. Safe working environment is another fundamental right of a working woman. In no way should working women be discriminated at the workplace against male employees. This is in tune with CEDAW or Convention on Elimination of All Forms of Discrimination against Women, which we have already dealt with in our lesson 1. Now, this is a kind of recap to see what are the major concerns under this Act. Creation of a complaints committee, that is internal committee in the enterprise itself, and two local committees, one at block level and the other at district level. Statutory compliance, capacity building, sensitization of employees. Sensitization of employees is very important in this case, as often the cases related with sexual harassment have a marked power imbalance between the victim and the accused, which usually makes the victim suffer even more. So, sensitization of employees is a very important step in this direction, so that at least the victim, they will come out and say that they have faced any kind of harassment, and so that requisite action could be taken in that direction. Now, journey ahead. It was recommended that in order to have a fruitful result from this particular act, there is a need to invoke strong commitment to the cause of women, so that we could tap the vast human capital which is somehow exited from our workforce owing to the hostile work conditions, involve diligent investigative mechanisms, manage issues effectively, and also the proper compliance of the Act. Already the Act provides for penalties so as to do away with non-compliance of the Act. Now, this was all about the Sexual Harassment of Women at Workplace, Prevention, Prohibition and Redressal Act 2013. Thank you.